SRM in Keroka law courts. One of the matters I handled was a stroke 2 matter, robbery with violence matter. And at that point, based on my interpretation then, I did not give the death sentence. Where the matter went on terms of the directions they have given on the sentencing of similar matters. Yes, my lady.
Okay, even where the Court of Appeal has not followed the decision of the Supreme Court?
Where there's a decision of the Supreme Court, of course, that will be the binding decision. Yes, my lady.
Okay.
Yes.
Very well.
Thank you, Honorable CJ. Your Honor, I have a few questions for you. I also congratulate you on your promotion to be Chief Magistrate.
Thank you, Judge.
I noticed that in your CV, yes.
So that it supports the evidence of the primary witness.
Yes.
Yes.
Okay. So, where is corroboration mandatory? Corroborating evidence mandatory? Because we also know in some cases,
yes,
the circumstantial evidence is admissible. Circumstantial evidence.
That's true.
But where is it, or rather, where does the law require that as much as possible there should be corroboration?
Thank you, Commissioner. Yes, if the court is convinced, and that is why it then calls for the court to be able to, in the course of the ruling or the judgment, the judge or the magistrate would require to bring that out in the ruling or judgment as to why they are going to rely on the evidence of one person. Of course, it would be where the evidence is clear. For example, identification is not in dispute, and the perpetrator is probably known to the victim, and where no one else would have been available, maybe except for the purpose of evidence like that of a doctor who comes after the fact.
Okay.
Yes.
Section 124 of the Evidence Act. The areas where, when there are court evidence of a sole witness. Yes. Okay. I was trying to point out the section.
Thank you, Commissioner.
Yeah, now, in your career as a magistrate,
yes,
is there a case where you feel that your decision was standing out? It was, even in that context, a milestone in the jurisprudence of your court? Because jurisprudence is not only made in the High Court.
That's true.
Yeah, even in the magistracy.
I think the case that comes to mind almost immediately is the case I've just mentioned in Keroka. Of course, I was trying to test the jurisprudence and case law for that matter, because at that point we did not have jurisprudence on any other sentence apart from the death sentence for stroke 2 matters.
Okay.
Yes.
Thank you. Lastly, I saw in some of the comments given internally by DPOC,
yes,
that you are very committed in your work, and they gave an example that to show your commitment, you are able to assist the Ruiru courts in hearing cases before you are assigned full-time to that station in sometime in August 2023. Is that correct?
Thank you, Judge, for the compliment. It's true, because I actually began.
I don't know whether it will come to that after my next question. Whether it's a compliment, okay?
Yes, I began it actually in March 2022, before even we rolled out the Mahakama Popote formally.
Oh.
It was before the formal rollout.
Okay.
Yes.
So where were you at that time, formally posted?
That time I was serving, let me say, full-time at the Chief Registrar's office and at the tribunal.
Okay.
Micro and small enterprise.
Were you assigned to go and assist in rural?
Yes, I had a formal assignment.
Okay, in writing?
Yes.
Okay.
Yes.
Because I was worried that you just volunteered to, and I was going to wonder why did you volunteer for, and who gave you authority?
Of course, I had engagement both with the chief registrar and the registrar magistrate courts then,
Yeah.
and it was formalized.
Okay.
Yes.
Fine. Okay. Thank you very much. I wish you all the best.
Thank you so much, Judge.
Otherwise, I've read your writings,
Yes.
and I've seen the quality of your judgments and rulings.
Thank you. Thank you, Commissioner.
Thank you, Honorable Chair. Good morning once again, Your Honor.
Good morning, Commissioner.
And congratulations on being elevated to the position of Chief Magistrate.
Thank you so much.
As a judge, you'll be expected to interpret the Constitution. What approach would you use? And I would suggest that you make reference to the Constitution and any decided case.
Thank you, Commissioner. Yes, as a judge, especially of the High Court, one of the mandates that the Constitution gives is the interpretation of the Constitution. I would take what I would call, or what the other Constitution calls, a purposive approach in terms of the interpretation should allow for the widest benefit to the parties in terms of the provisions of the Constitution that apply to them at any particular time. So I would take a purposive approach in the interpretation of the Constitution. My apology, I can't think immediately of a specific case.
And the actual article of the Constitution?
I would have to look that up.
Okay. And what is purposive interpretation?
Purposive interpretation is what I would call where you go beyond what I would call the letter of the law into the spirit of the law, in terms of what were the drafters' expectation in providing for some of those provisions in the Constitution that are the subject of the interpretation, so that I'm able to allow for the petitioner or the party to have the widest possible benefit from that provision of the Constitution or article of the Constitution.
Okay. And under Article 2.5, general rules of international law shall form part of the laws of Kenya. What is your understanding of general rules of international law? And you can also make reference to how that particular provision of the Constitution has been expounded by a superior court in Kenya.
Thank you, Commissioner. General rules of international law, I would distinguish them from what is provided for under Article 2.6, where there are those treaties and conventions that have been ratified specifically by process. But there are those that have not been specifically ratified, but which are accepted. It's like what I would call the international common law, which states do follow.
Common law or customary law?
Customary law, sorry. Yes. So where a country like Kenya may not have ratified specific conventions or treaties, but there are some customs that are, so long as they're not inconsistent with our Constitution, then they can be applied. I would need to look up specific cases where they have been applied. Yes.
Okay. And lastly, have you attended any AJS training?
Personally, no.
Okay.
Not yet.
There is what is called the agency theory of jurisdiction that is supposed to aid courts in determining whether cases are fit for AJS or not. Do you know anything about the agency theory of jurisdiction?
My apologies, I haven't interacted with it.
Okay, best. Thank you, Honorable CJ.
Thank you, Commissioner.
Thank you, Chair. Good morning once again.
Good morning, Commissioner.
I also want to join my colleagues in congratulating you for being promoted to the position of Chief Magistrate.
Thank you, Commissioner.
It is well deserved.
Thank you.
Yes, congratulations.
Thank you.
Now, the first question I have is on the oxygen principles.
Yes.
What are they? And number two, just explain to us, as a judge, how you will assist in achieving the objectives of those principles.
Thank you, Commissioner. I would, in a nutshell, describe or define the Oyo Principles as being what we call the overriding objectives that are there under the CPA. And basically the purpose is to facilitate, rather to allow the courts to facilitate the expeditious disposal of their cases without too much reliance on technicalities. And
That is one of the objectives.
Yes.
Expeditious disposal of cases.
Yes.
Any other? Okay.
Yes.
Now that you have only one, then tell us how, as a judge,
Yes.
you will assist in achieving that objective.
Thank you, Commissioner. I would put in place the mechanism, actually what I'm already practicing, both at the tribunal and at Ruiru law courts, in terms of giving evidence to the mechanisms like ADR, relates arbitration where applicable, or mediation, especially the court-annexed mediation, which I've had the privilege of participating in the judiciary to determine some of the matters that we deal with. Of course, in inappropriate cases, I would also go for mechanisms like diversion in appropriate cases, so that they will not have so many matters either coming to the court, or if they come to court, they don't have to go through the full trial process in that. And then, of course, applying a little more strictly what I level in terms of case management. Unfortunately, that is one of the good things that has come out both of under the amendments that were done in 2010, to have the court have more control in terms of that. And one of the things we've done, maybe just to mention as a close, that is that when we are doing Order 11, at least for my court, that is Ruiru, and that is not just me but all the magistrates who work there, one of the issues we constantly tell parties that even as you comply with Order 11, nothing stops you from engaging.
Okay.
To be able to, so that at the time you're coming for the hearing, if you have a consent, if you have some of the matters narrowed down, then
actually that is part of Order 11,
yes,
to explore possibilities of settlement.
Absolutely.
Okay. Now, one other initiative that we normally use to try and address or expedite hearing of cases or disposal of cases, and also address the issue of backlog, is service weeks.
Yes.
Could you tell us how service weeks work?
Thank you, Commissioner. Now, service weeks work, I would put it in two categories. The first is where we have a backlog, actual backlog, so that then the service week is supposed to come to be like an RRI, a rapid response initiative, to deal with a certain number of cases for a particular time, especially the old cases that are ready for hearing, so that if I have 100 cases and I'm asking my colleagues to come and assist, as much as possible, they should be able to come and hear them to conclusion, that we only remain with submissions and either rulings or judgments in appropriate cases. So ideally, where we do not have a backlog, it would not be appropriate to have an RRI. For example, last year when we were doing the Children's Week, when we did our evaluation, we only had 10 cases. So 10 cases for 3 magistrates who are already in site would not warrant
a service week.
Service week.
Okay. Now I have your performance report here from
Yes.
DPOP.
Yes.
I just want us to engage briefly on it.
Thank you.
Have you been given a copy?
Yes, I have a copy.
So you verified that it's accurate?
Yes, I've been able to engage them. It's accurate.
Okay.
Yes.
It's for the period from 1st July 2023 to 31st December 2023.
Yes.
And your output doesn't look very impressive compared to what the others are doing. You are expected to carry 25%. You are 4 in Ruiru, 4 magistrates, right?
Technically 3, because the 4th magistrate is an adjudicator. And because of the number of matters that were filed under small claims.
So the 4th magistrate is a small claims court?
Yes, yes.
Oh, okay.
So they are 3.
So 9% out of 25?
Yes, and it's true, but that is because between 1st July and 30th October, I still had the 1 day I used to serve in Ruiru.
Oh, okay.
But now, the 9 actually is mostly actually for December. I'm saying that December because from mid-October to mid-November, we were involved in the performance evaluation. So I began
So
to
you were
sit
not
properly
sitting then?
in December.
Oh, okay.
Yes, so it looks
That-
low, but I think for 1 month, it's not, not a very bad one.
Okay.
Yes,
That explains it.
yes.
The other area I wanted to engage you on was on your court productivity vis-a-vis your case clearance rate.
Yes,
The court productivity is at 723,
yes,
way above the national average of 299.
yes.
Yet your clearance rate, case clearance rate, is at 96 against 104.
Yes.
What does this tell you?
For the court, and that is true also, and I would explain it in this way. Prior to my going to Ruiru, there were actually basically 2 magistrates.
Mm-hmm.
I'm saying that because my immediate predecessor, who became RHC, technically left in May.
Mm-hmm.
So between May and until when I reported for, properly in December, there were 2 magistrates who were handling the entire workload. Apart from now, us who were handling the Mahakama reporting initiative. So in view of those circumstances, I think they did not perform badly. The station did not perform badly. And
I'm not even saying it's bad performance, by the
yes,
way.
Yes.
It could be very good performance.
Yes.
You see, comparing the court productivity,
Yes.
how we arrive at the court productivity is the output of the entire court divided by the number of JOs that are there, isn't
Yes,
it?
that's true.
So each JO was clearing 723 cases, while nationwide on average, we only do 299 cases.
That's true.
But at the same time,
Yes.
the amount of work you are receiving, you only cleared 96% of it.
Which is, I could give this explanation, Honorable Commissioner. Maybe unknown to many people, Ruiru is a very busy station. In every year, we record in excess of 6,000
Mm-hmm.
cases, both civil and criminal. Of course, we also have land and employment matters. So with that kind of caseload, and with the transition, then we are not able to easily hit 100% in terms of case clearance. I would indicate that the 94% is actually a very hard effort.
96.
96% by
Okay.
the JOs who are on the station.
You seem to be doing well also on productivity, just like I had mentioned,
Yes.
but the court satisfaction index is rather low at
Yes.
55%. This is from your customers now.
Yes.
55% against the national average of 66. What exactly is the grievance of the customers of Ruiru Court around the administration of justice there, or even just the court?
Thank you, Commissioner. That satisfaction was actually undertaken in 2019,
Mm-hmm.
when the court had just begun.
Mm-hmm.
So I would not be surprised if it was based on the teething challenges of setting up a new court.
Oh, okay.
Systems, you are having new staff. Actually, most of the staff were new staff who had just been employed. You are setting up a registry. And just to mention, of course, with an invite to the Commission to visit Ruiru one of these days, is that Ruiru basically has got no physical infrastructure. We normally joke that we work under trees, and therefore it could affect the satisfaction that our customers and even our staff would have in 2019. I believe if the same was done today, probably would be above 75%. I pride Ruiru with the kind of systems and engagements we've had with our clients, and I would even challenge the Commission, if you send an email, you can get a response within an hour without having to follow up.
Okay, I hope my sister, Commissioner Ngute, will be able to corroborate that. Thank you, my lady.
Thank you. Thank you.
Thank you, Honorable Chair. Your Honor, I have only one question for you.
Yes,
and I
Commissioner.
also want to take this opportunity to congratulate you on your promotion.
Thank you, Commissioner.
Now, what is judicial activism, and is it anchored in the Constitution?
Let me begin with the second part. I would not say that it's directly anchored in the Constitution, but judicial activism is whereby a judge or a magistrate, for that matter, in the course of making a determination, allows a bit of their personal, I'm looking for the correct English word, allows for a bit of their personal thoughts about a matter to get into the decision. An example would be, for example, if I am determining a sexual offences case, for example, of the Constitution. So there is what I would call purposeful activism that then would be appropriate, but not what I would call extremistism. Yes.
Thank you, Chair. Now, Bwanawere, Mheshimiwa, can you tell us some of the things that achievements which can be described as ascribed to you directly as a result of your leadership and vision? I know you've still been in leadership positions in spite of the fact that recently you ascended to the Chief Magistrate's office. But I'm sure you must have had some impact on the judiciary in some form.
Thank you, Commissioner. The first I would say was the impact that I brought about in the organization, because that is the time when I joined the Chief Registrar's office. And maybe just to give a background, that at that point the Chief Registrar did not have a deputy Chief Registrar, and therefore she relied a lot on myself and my colleagues to basically run her office, both in terms of external engagements and internal engagements. And one of the things we did very quickly was to reorganize the office into responsible sections based on their mandate, so that then, for example, advocate section, we had a lead person in advocate section, that all matters advocates, we have a responsible person who deals with them at certain level before you escalate on a need basis. And we've seen that vision that has come with, for example, the admission process. Right now, those days you'd have sleepless nights even with 100 lawyers being admitted. Right now, if you bring 1,000, we will not even squeal, so to speak, because you have been able to streamline our processes. Number two, the other thing that has come very strongly and is related to that has been our engagement with our external lawyers, especially in the matters in which we were parties either as plaintiff claimants or respondent to defendants. And when they came in, there was a lot of communication that had not been responded to. They didn't have instructions. Matters were stalling. Some of them we were losing because we were not able to raise witnesses. So one of the things you've done very robustly is, number one, is to streamline that registry. And we are able to virtually respond to all matters for the interest of the institution. And in the process, you have been able to protect, so to speak, the interests of the institution. Not to mention, we have been streamlined leadership things like in the swearing-in processes, right from all state officers to the presidential swearing-in processes. We have been able to streamline through the, and which have been strongly involved in the management of courts through the heads of station forum. And we are seeing much better management of our court. A good example was that in 2019, if I remember well, 2019, 2020, we devoted our time with the heads of station on dealing with the financial management, just to reduce issues of audit queries. And we came to learn that Some of them is we appointed heads of station. There's no like induction or orientation to guide them in terms of once you land in Ruiru, for example, and you've never been a head of station, and how do you manage that? You need to be an HR officer, you need to be a finance officer, you need to be a procurement officer, you need to be a public relations officer. So all these are subsumed in the role that heads of station play. And if you go to the courts recently, I guess you will find very different management that the courts are having.
Okay, thank you, Chair.
Thank you, Honorable Chair. Honorable Were, mine is to join my colleagues in congratulating you for your elevation to the position of CM.
Thank you, Commissioner.
Now, I only have one question for you. Please tell us that one thing that you're planning to bring on board as a judge that you feel you've not had the opportunity to bring forth as a magistrate.
One of the things I'm planning to bring on board, so to speak, would be to apply my skills, especially in the area of backlog reduction, and basically to apply the various experiences I have had. I'm saying that because at the risk of repetition, when we go around, we realize there are small things we can do that have got big impact. Now, not just for me as a judge, but I would join forces, if I'm sent to a station, I would join forces with my principal, with my presiding judge, to deal also with the courts that fall under, so that if we are in a jurisdiction, let's say with 5, 7, 10 courts, then we are able to ensure that all those courts, actually, in terms of performance, are able to move together. So I think, and I'm saying this because one of the things that really disturbs me is taking too long in the system, and that is one thing I would want to have a continuous impact. If I went to a station, assuming that the commission allows me to be a judge, one of the things I would ask my presiding judge, what are the quick wins we can do? Do we have pending appeals that we can dispose with very quickly? Do we have revisions that I can quickly handle, so I do not have anything pending? Do we have applications that can be disposed of by way of submissions, that we can be able to invite parties, give them directions on filing of submissions, and then be able to make a determination to allow those matters either to come to a conclusion or to move to the next stage of their trial.
You don't feel you're already doing that as a magistrate in terms of case log clearance? Backlog, sorry.
Yes, I am doing, but as a magistrate, there is that confinement to Ruiru locals.
Okay.
I am looking to have a bigger impact. As a judge, you have a bigger
Okay.
impact.
Okay.
Yes.
All right.
And of course, as a judge, you're dealing with matters of higher value, with therefore more pressures on the parties, in terms of quick resolution.
Okay.
Yes.
Thank you, Honorable Were. I wish you well.
Thank you, Commissioner.
Thank you, Commissioners. I was listening to hear whether you would also decongest prison, whether you would bring forward cases involving children,
Yes.
or whether you would also look at succession matters that are clogging the system to see how you can deal with them. But wish you well.
Thank you, CJ.
Yes, I think this brings us to the end of the interview, unless you have a question for us.
Madam CJ and Honorable Commissioners, I do not have a question, but just to express my unreserved gratitude for being given the opportunity to come for this interview. I appreciate that the Commission is dealing with about 98 of us, minus those who have who might not come for the interviews for 20 positions. I honestly don't envy you, but I know that you will have the wisdom to do that. Only to give a commitment that given the opportunity, I will do my diligent service as I've always